Welcome to Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our website is libertylawtalk.org, where you can subscribe, comment, find other episodes and links relevant to today's conversation. Our email address is mail@libertylawtalk.org. We'd love to hear from you. Today we are discussing with Stephen Knott his book, Rush to Judgment, George W. Bush, The War on Terror, and His Critics. Stephen Knott is Professor of National Security Affairs at the United States Naval War College and the author of Alexander Hamilton and the Persistence of Myth, Secret and Sanctioned Covert Operations and the American Presidency, and At Reagan's Side, Insiders' Recollections from Sacramento to the White House. Stephen, great to have you on the program.
Oh, thanks for having me, Richard.
So at the outset, distill for us the understanding of executive power that George W. Bush had and which he operated from while he was in the White House. Because I think, and your book does this well, there's a lot of just misunderstanding in general about what he understood the Constitution authorized him to do, what he was actually doing, and the precedents, history, practices that he and his advisors were operating within and thought justified what they were doing.
Well, I see George W. Bush very much in the tradition of Alexander Hamilton's energetic executive, acting as an energetic executive, particularly when it came to national security threats against the United States. Now, having said that, I would never argue that George W. Bush had a particularly strong grasp of Hamilton and the founders. I'm not quite sure. I don't think he did. And unfortunately, you sort of see that in a kind of lack of, there are very, very few references in Bush's speeches to historical precedents regarding the use of presidential power, particularly in facing an emergency situation. And I wish he had done more of that. So let me sort of qualify that by saying, yes, I think Bush acted in a kind of Hamiltonian tradition, but I don't think he did a particularly good job of justifying many of his emergency measures. It's also clear to me that while I reject the idea that Dick Cheney sort of pulled the strings during the Bush administration, or certainly did not control George W. Bush, like many liberal observers contend, it's also true that I think Cheney and some of his close associates, David Addington and others, did have a pretty clear grasp of the founders' position, or certainly Hamilton's position, on presidential emergency power, and did make a far better case than the president himself did to justify some of his actions. So, and of course, Cheney, having served on the Iran-Contra Committee, was one of the key authors of a minority report which dissented from some of the critics of President Reagan's actions during the Iran-Contra affair. And Cheney, with Addington at his side, published a report that is just filled with references to some of these earlier examples of presidents using what came to be known as prerogative power or emergency power to face various crises. That includes Jefferson's use of it during the Chesapeake Crisis of 1807, or Lincoln's suspension of habeas corpus, or Franklin Roosevelt's actions during the Second World War. I think Cheney was quite familiar with this history. I'm less convinced that Bush was. But nonetheless, President Bush, I think, did act in a manner that was consistent with the principles and practices of many of his illustrious predecessors.
Yeah, no. When I asked that question, I said George W. Bush, but I largely meant the George W. Bush administration.
Okay.
And those
Sure.
acting within it, Office of Legal Counsel, David Addington certainly, Dick Cheney as well, just from my own recollections of how all of these guys kind of working together, conversating together, informing one another about how they would justify or how they did justify their actions. So you mentioned prerogative power. That's an important term. Most people place it in the American context, and most directly in John Locke's two treatises of government, where he suggests executive power by its very nature can't be precisely defined and limited, and a certain prerogative, a certain extra legal action of necessity will have to be taken. How does that work its way into the American Constitution, or how do you think it works its way into the document?
Yeah, sure. Well, for instance, I mean, I think there's a pretty strong case to be made that the Constitution, the framing of the Constitution itself, was an act of prerogative power. The delegates who were sent to Philadelphia in the spring of 1787, many of them were just assuming they were going to tweak the existing articles. And, they end up coming out a few months later having scrapped the whole system and changing the rules by which you could change the Articles of Confederation. So, in a sense, they've changed the rules in the middle of the game, and that, to me, strikes me as a perfect example of prerogative power. They're responding to what they perceive to be an emergency, and I know some anti-federalists would quibble with that description, but they did. And Madison, I believe, somewhere in the Federalist Papers, makes the case that these delegates to the convention were responding to a higher duty, a higher call. They were responding to what they saw as something of a threat to the national interest, and they acted accordingly. But if you sort of follow the rules strictly, what they did, I think, fits the bill perfectly in terms of prerogative power.
Now we could also say they did submit their work to the people assembled
Absolutely.
in popular convention for approval.
Very good point.
Yeah,
Yep.
no, I on the prerogative power question. I mean, so if you look at Article 1, we've got a detailed list of powers that Congress has and the ways that they're limited in the exercise of those powers. Article 2, we have things like executive power, the take care clause, the commander-in-chief, the oath, which you spend a good deal of time talking about as well. So I guess fitting within there, how do these terms, and this is a broad question, I'll let you answer it at length, how do these terms sort of inform this idea of either inherent power, prerogative power, and not that those are the same, but these sorts of things that seem to be implicit in the text but not yet spelled out?
Right. And I think they are implicit in the text, and I think the term, the executive power, shall be vested in a president of the United States. I know some have contended that line was almost a kind of throwaway line, sort of something that you pull off a template, but I think for many of the founders that had real meaning, and it was precisely what you said. These were people who were influenced by the writings of people like John Locke and considered executive power to be the ability of the head of state in times of emergency to deal with threats to the very existence of the nation. Look, I'm not somebody, I'm completely aware, excuse me, of how this kind of power can be abused. I just want to make that clear from the start. And I think it has been abused, and it's been abused by people like Richard Nixon, for instance. I do go on to try to make the case, however, that I think George W. Bush's actions, at least in the aftermath of 9/11, fit well within the confines of a sort of just and healthy use of prerogative power. But again, back to Article 2, I see it in the very first sentence of Article 2. I see it, as you mentioned, in the oath, which, of course, Abraham Lincoln made a considerable effort to sort of cite the oath, the fact that the presidency is the only branch of the federal government where the constitutional oath is the language is written right into the Constitution itself, and it's his responsibility to preserve, protect, and defend. And Lincoln took that preservation clause quite seriously, and I think George W. Bush did as well, and rightly so. And then I see some aspects of this linked to the president's power as commander-in-chief. Not that that's not a power. War power, of course, is shared with Congress, but President Bush, at least unlike the current president, went to Congress in both instances, both with the war in Afghanistan and the war in Iraq. So, again, I see Bush's exercise of this power to be consistent with the principles and practices of the framers, and I think the threat presented by Al-Qaeda at the time and a lot of uncertainty surrounding their future intentions, he responded in a way any responsible president would have.
Now, in your book, you deal at length with the criticisms of Bush, which are criticisms, but are really denunciations of his understanding of executive power and the things that he did, and sort of the big categories: detainees, surveillance, choosing to fight abroad and the various ways, all these sorts of just the list of categories of things he did that he was criticized for. And I think you note the failure or refusal to deal with past precedent and past practice, which seemed to justify a lot of what he was doing. But let me ask you this question: more balanced and nuanced criticisms of George W. Bush, particularly those offered by Jack Goldsmith in The Terror Presidency, the book he released in 2000, published in 2007. He claims in the book that, and he makes a lot of careful qualifications, and does not seem to be, from my read, really denouncing what George W. Bush did, but he said there was a theory of prerogative power that was coterminous with emergency, that George W. Bush, and particularly quotes David Addington at length, had the power to meet any emergency on his own, and that it was constitutional, and he really didn't need to answer for it. This seems to me something different. Goldsmith, I think Goldsmith makes a good case. It's different from the way FDR did things that were extra constitutional. It's different from even what Abraham Lincoln did. Lincoln, of course, acts above the Constitution after the firing on Fort Sumter, but then goes to Congress and seeks approval and ratification. And Goldsmith argues that the Bush administration, in a lot of ways, didn't believe it needed to go to Congress for anything. It had these powers in its own right, and that, he says, is where they got into trouble.
Mm-hmm. Well, I think certainly people like John Yoo in the Office of Legal Counsel is probably someone that Goldsmith had in mind when he was wrote this book. I'm not quite sure I share Goldsmith's view of the history. I mean, Lincoln waited. He could have called Congress back into session when he took a number of these emergency steps in April 1861. Granted, the country was disintegrating. Granted, the southern states obviously would not have sent their representative. But Lincoln did not. He chose not to do so. And it's not until July 4th, I believe, that Congress finally arrives back in town. So I think there's a kind of mythology out there that a lot of what Lincoln did was above board, and as you know from reading my book, there are examples where Lincoln did not act above board. And I'm a great admirer of Abraham Lincoln, but I'm not sure we benefit by continuing to circulate what I see as myths. Lincoln did operate in secret at times. Lincoln did not inform Congress of a number of his I don't know if they qualify as emergency measures, but they certainly are somewhat controversial and covert measures. And I'm talking about his influencing elections in both Connecticut and New Hampshire, gubernatorial elections, where he thought the peace Democrats were going to win those elections and possibly withdraw those states from the Union. That's an aspect of Lincoln's presidency that people just choose to ignore. And to me, it speaks volumes that even Lincoln was willing, if need be, to take these kinds of extraordinary measures. Now, again, let me just repeat, I'm aware of the potential dangers of this kind of activity. I'm not that naive. I know my American history, and I know it can be abused. And again, with FDR, FDR was one of the most secretive. This idea that FDR operated above board, for instance, in the 1930s when he was covertly encouraging assistance to the Flying Tigers, who were American volunteers operating in China who were fighting against the Japanese. This was an aspect of FDR's presidency that was conducted entirely covertly and without any congressional awareness. And again, I think we've got this kind of, I've read Jack Goldsmith's work. I think it's good, but I think he does share in a kind of it's a very rosy view of American history. And this idea that somehow Bush and Cheney represented a fundamental break with presidential practices, I just don't see it.
Yeah, no, I think I would say, I'm not saying that they represent, I don't know if I would put it as a fundamental break, but it's a further ratchet up that doesn't seem to have a limiting principle. And I certainly don't share any sort of mythologizing of Lincoln or FDR. It seems in the big picture cases, particularly right in that period right after Fort Sumter when there's the catalog of extra constitutional things Abraham Lincoln does, he does go before Congress, and he is willing to, in effect, seek either ratification or not ratification for what he did, and that, of course, has been consistent with what Thomas Jefferson had said as well regarding the need for prerogative power, but the corollary, be willing to be publicly denounced for doing it if the public chooses to. It does seem, particularly with George W. Bush, when you read these accounts of what happened inside the administration, the view was, and Goldsmith also argues, they could have made themselves stronger if they had actually gone to Congress to seek authorization for things.
Right. Well, let me just say, Richard. Let me say, at least in regards to some of the items that you mentioned, the treatment of detainees, the warrantless wiretapping, Congress. It would be a mistake to say that the entire Congress was informed. They were not. But clearly the intelligence committees of Congress were informed about some of the more controversial initiatives that the Bush administration took. And I'm talking about the fact that people like Nancy Pelosi were briefed about the waterboarding program. Pelosi wasn't alone, of course. There were others. They knew about the warrantless wiretapping. I mean, this idea that somehow they were kept in the dark is also mythology. Now, again, was it announced publicly? Was it announced to all 535 members? No. But there was certainly an amount of information sharing with the intelligence committees in the House and the Senate that in some ways that's the way the system was supposed to work. And it's not as if the Bush people circumvented that process. They didn't. Yeah.
On thinking about what you're saying there with regard to the way they're related to Congress and sort of these contextual considerations, it seems also we can say there are these precedents that could be utilized or were utilized to justify a lot of things the Bush administration did, but there was also something else that developed. In particular, say, from FDR's administration to George W. Bush's administration, and we've already touched on Richard Nixon a little bit, and that's Watergate and the Vietnam War and perceived and real abuses of power by the president, by Richard Nixon, and also Lyndon Baines Johnson being less than forthcoming about a lot of things as well. And this had really influenced America. And thinking about executive power, we've also got kind of the rights revolutions as well that go on in Western liberal democracies. And also we can say, right, the executive branch, the CIA, the military, suffused with lawyers now. Hemming in everything they do, questioning everything you do. CIA agents, I didn't know this, they are encouraged to get, when they come into the agency, they're encouraged to get insurance, litigation insurance for things they might be held accountable for. All of this working, and so I can understand the Bush administration, and that that the way this would push against you, you've got to push against this as well. Not just you're dealing with the terrorists, but you've got to think about the lawyers and the way that's hemming you in. And it seems to me this really creates a lot of bad outcomes. But thinking about all that, those sort of contextual considerations, I wondered if the Bush administration was there a failure to prudentially realize that while there could be a lot of precedent supporting what they were doing with regard to, say, military commissions, fundamentally legal international opinion had changed on these questions, and did they take that into account?
Yeah, it's a great question, and it's possible that they failed to take that into account, but I guess I would come down more on the side of they took it into account and decided to try to push back against it. And I'm thinking especially, I know that was the position of Vice President Cheney and the people around him. And, of course, keep in mind that Cheney had been Gerald Ford's chief of staff in the mid-'70s when the whole Church Committee and Pike Committee investigations into the secret arms of government were well underway. And Cheney really, to some extent, had spent the last 20, 30 years of his career kind of pushing back against that. And I think he viewed, not to sound callous, but he viewed 9/11 as an opportunity to try to reverse those trends. And that included the notion that certain aspects of international law should trump his understanding of the American Constitution and the Article II powers given to the president. So I think they were aware of it. I think they just thought they might be in a position to reverse it, and I think in the end they were disappointed. They failed.
Yeah.
And to be perfectly honest, as I've probably already made clear, I do think a lot of those, I think I refer to it as a kind of quiet constitutional revolution that began in the mid-'70s, where you had a kind of erosion of presidential control over agencies like the CIA, and even to some extent, I suppose you could argue, in the war powers arena, although that's been less successful as far as Congress is concerned. But I think that was a healthy attempt. I do think some of the congressional edicts that were issued between 1975 and 2001 did chip away at the ability of the United States intelligence community to penetrate organizations like Al-Qaeda. You just can't do it with Girl Scouts. And any time the agency would sort of engage with unscrupulous characters, which I think is unfortunately the nature of the clandestine world, they'd get their hands slapped by Congress. So I think Congress bears some element of responsibility for the events that occurred in terms of the rise of Al-Qaeda between 96 and 2001.
And you talk about at length the Clinton administration confronting Al-Qaeda, confronting Osama bin Laden and others. One, we could say they, and others inside the Clinton administration have said they weren't focused as they should be, or they didn't respond in the manner that was required after the kind of series of attacks in the late 90s that occurred during the administration. But there was also, particularly with Osama bin Laden, there's the famous story of him being in the crosshairs, and there's the decision not to execute him because of fear of international law, treaties, et cetera, all sorts of things working together. So this is all part of the problem, and as we're discussing, that George W. Bush and the administration is working within. On surveillance, I wanted to talk with you about this because this has really obviously emerged with the Snowden cache that's been released to certain reporters as being something that very few people I'll say defend, but it's hard to justify. It seems constitutionally, it's much broader than what we thought, and as many people have uncovered, the legal justifications for it were not widely circulated within the administration, seem to be quiet and blatantly disregard the FISA law itself. And this kind of goes back to their understanding of prerogative power, and it was an elastic one that can meet any emergency, even disregarding the FISA courts in pursuit of their surveillance. Talk about that, how you understand that program, justifications for it, and then also I think the Snowden cache worth thinking about. There was a recent report in the Washington Post, 90% of 90% of the accounts are actually people not connected to any terrorism. They just seem to be swept up in the dragnet.
Yeah. Well, look, I think the position of the administration was that FISA, in part, was outmoded. It was passed, I think, in '78. It was passed before, it's pre-cell phone, pre-internet, every technological breakthrough you can think of. And I think there was a real concern that, and they did hear this from people in the FBI and the CIA, that it was slowing the process down, that minutes, counted in a situation like this. Keep in mind that I guess it would have been the NSA had intercepted on September 10th some interesting communications between known Al-Qaeda members, saying things like the match begins tomorrow, and coded language indicating that something was probably going to happen on September 11th. Unfortunately, that kind of stuff was not sort of processed until September 12th, 2001. So it was basically worthless. Now, would that have made a difference? Probably not, even if they had gotten it, sort of deciphered it more rapidly. But, I understand that there are genuine civil liberties concerns here. I also understand that as president, when you're sitting in the Oval Office on September 12th, I probably would have done the very same thing that George W. Bush did when he called in Attorney General Ashcroft and FBI Director Mueller and basically said to them, don't let this happen again. In fact, that is what he said to them. And that's the road, that's the beginning of the path down towards that leads to enhanced interrogation techniques and warrantless wiretapping, and so forth. And then when you have people telling you that there are certain delays associated with getting the FISA courts to act, it's a tempting thing to do, to say, let's just circumvent that. We've got a real situation on our hands here. And I know it sounds like an episode from 24, and that I'm somebody who's, a fearmonger or whatever, but the fact was that in October of 2001, CIA Director Tenet told President Bush that Al-Qaeda had already slipped some type of dirty bomb into the United States. They believed it was in New York City, and they were just waiting for the other shoe to drop. And at least I would ask your audience to consider the question, well, what would you have done had you been in Bush's position?
No. I had that in the back of my mind the entire time I'm reading your book. I was unaware of that particular issue. It was a 10-kiloton nuclear weapon they feared. That's an incredible. That would be an incredible thing. And you write that Dick Cheney was taken to an underground bunker of some kind with like 100 employees.
Correct.
Yeah, that's incredible. I didn't know that. When was that publicly released? Do you know?
Oh, boy, that's a good question. I'm not sure, Richard. I will say this. If your readers have a hard time, or if your listeners have a hard time believing what I have to say, take a look at Peter Baker's book. He's a New York Times reporter who was certainly no friend of the Bush administration, who wrote a book called Days of Fire, which appeared, I think, within the last 9 months or so. Again, no Bush admirer by any stretch, but he also, and on top of the story that I just told you about the weapon in New York City, they were also convinced in the fall of 2001 that some sort of bioweapon had been smuggled into the Washington, D.C. area, and some detectors in and around the White House had gone off. So, I mean, it sounds, again, it sounds like a Hollywood movie, but this was the environment they were dealing with, and this, again, led President Bush to take these extraordinary measures.
Interesting. I mean, and I think, and apart from these specific episodes, general opinion was that something else was going to happen. There would be another hit. So I certainly remember that. Just an obvious question that comes to mind. Congress. I mean, everyone on board. And right after 9/11, with whatever needed to be done, witnessed the lack of debate around the Patriot Act, approved overwhelmingly. Why not seek something like that with regard to the FISA law?
Well, it's a great question, and there's certainly, I'm not somebody who takes the Bill of Rights lightly, and I think the Fourth Amendment is an important amendment. But I think there were probably some concerns that the less you say publicly, the more likely the enemy, Al-Qaeda, is going to continue to operate in the way they are used to operating. You don't want to give any hint or any indication that things are changing and allow the enemy to change its methods and tactics.
Yeah,
I'm not sure.
Yeah. Go ahead. No, the reason why I asked that question is I just kind of go back to an idea that Cheney, Addington, perhaps others, John Yoo, Jack Goldsmith refers to the War Council as being kind of 5 or 6 guys inside the administration. They had this conception of executive power that it really needed no justification for what they were doing, and I think that again just comes back to the obvious question of what's your limiting principle here. And so thinking about FISA, we don't. I guess the response to me would be we don't need a FISA revision or to accommodate these new technological realities. Of course, and going back to someone I've mentioned repeatedly in this interview, Goldsmith writes at length in the time he was head of OLC. He tries to clean up these OLC opinions.
Correct.
Because he just thinks they're just wildly overstated, the powers that they have. And that's interesting as well, just to think the OLC, these opinions are really seen as justifications for action by executive branch officials throughout the government. I mean, that to me is a truly incredible amount of power that, I mean, I guess the head of the OLC has to be approved by the Senate, but all these guys are mostly, I mean, I imagine you're really smart, people, and, you get in the OLC. But that's an incredible amount of power they hold. And again, this kind of goes back again to the fear of legality.
Sure. Absolutely.
That moves throughout government. Yeah.
No, absolutely. Let me also just, it's been a while since I've read Goldsmith's work, but I hope he doesn't point to FDR as an example of someone who was concerned about the civil liberties implications
No.
of warrantless wiretapping.
No, he did not.
Okay, because I mean, the FBI under Hoover during the FDR years was,
they had the whole town bugged, right?
They had the whole town bugged, and it usually involved political opponents, including Wendell Willkie and others. So, well, anyways, yeah.
No.
Which of course is why you end up with a FISA. I guess again, let me just try to make the point. I mean, if there was ever an instance where you might sanction or approve of a president's use of this kind of tactic, I think 9/11 and the immediate aftermath fits the bill. In other words, I don't see George W. Bush anywhere near in the same category as a Richard Nixon or a Lyndon Johnson, or even a Franklin Roosevelt, who used the secretive arms of government to monitor the activities of their political opponents. I'm not aware of any allegation of Bush doing this.
No, I think that's
so.
lost.
What we're talking about are people who are trying to contact folks in Afghanistan or Yemen on a regular basis that raised a red flag and were sort of immediately subject to this kind of warrantless wiretapping. But that, to me, is light years away from wiretapping Wendell Willkie or planting bugs on Barry Goldwater's campaign plane.
No, and that's a good point. Of course, we can also think about the incredible amount of data they were able to collect, say, under the surveillance program, and being able to utilize all of the major private communications companies to do this. Now, we can say it's justified, and really they're only looking for terrorists and those with direct connections to them. But it seems to me, again, thinking about what Snowden revealed and thinking about a lot of the investigations that have come out after the fact, it presents, just the thinking about, you don't have to read the contents of someone's cell phone call, but you can really understand a lot about them just by knowing their location. And that, of course, is within the dragnet. All of these sorts of things, I think, make people incredibly uneasy, justifiably so. And again, you look for, well, what's really going to limit the government from using this? And now we don't have any documented instance that I know of it being unlawfully used, but that is really kind of cold comfort, I think, to most people.
Oh, sure. And let me just note, by the way, again, I'm somebody who takes the Constitution seriously. I certainly take the Bill of Rights seriously. I would add, however, that the practice of sort of violating private communications has deep American roots, and I'm thinking particularly of George Washington's encouragement of mail openings during the Revolutionary War era. I grant you that's pre-Bill of Rights, pre-Constitution, but Washington was a firm believer in the merits of intelligence gathering through mail openings. In other words, there were suspected Tories inside the United States who were, communicating with the British. Washington had a fairly extensive intelligence network, and they devoted a great amount of effort in intercepting these mails, opening the mail, reading them. Washington even provided instructions as to how to open an envelope, read the contents, and then reseal it and send it back on its way. So, this was a guy, here's our founding father, who seems very comfortable with the notion that in wartime, that kind of intelligence is valuable in terms of protecting the national interest.
Mm-hmm. Thinking, though, maybe I just want to ask you a broad question here about the Bush-Cheney administration. Let's say, Cheney, one of the authors of the Minority Report of the Iran-Contra scandal,
mm-hmm.
And let's say he sets out to increase executive power while he's vice president, or to be a part of a process that does that. When George W. Bush leaves office, did they succeed?
Did they succeed?
And expanding executive power from the baseline it would have been in when they came into office, and the manner in which they wanted to do it, that they thought was constitutional.
No, I actually think in the end they did not succeed. Now, again, that may come as a shock to some folks who are listening to this in light of the Snowden allegations. But I think what we've seen pretty much since 2000, really since the Iraq War started to go south, has been a fairly concerted pushback against a number of these initiatives, and that pushback, I think, succeeded quite well. In other words, I don't I think there's a good case to be made that in January 20th, 2009, the presidency, Bush left the presidency in some ways weaker than he found it.
Yeah. Yeah, no, I tend to agree with you. I mean, in one sense, if we just think about the three major Supreme Court opinions on detainees,
exactly,
and actually,
exactly,
yeah,
exactly.
yeah, those are. I mean, one, truly breathtaking in their scope and what they are basically implying or explicitly saying that the judiciary being involved in wartime decision making. It seems that goes to though. I mean, and I also think those are activist decisions. And they seem to be guided or supported publicly and probably inside the minds of the judicial, of the justices, by the perception that this was a president who was running away with power and Congress refused to check him.
That's correct. But again, I would see that understanding that I think the majority of those justices did have that understanding, but that again is a reflection of a kind of post-Watergate, post-Vietnam mindset. I think if you put it in the grand scheme of American history, that's a new approach for the judiciary to take. Throughout our history, the judiciary has tended, I think, to defer to the executive in times of war. So you're absolutely right that those three decisions, Hamdan and the others during the Bush years, represent a significant reversal of past practice. And as you know, I've got a chapter in the book where I'm very, very critical of the increased role of the judiciary in these kinds of war-related matters. These are clearly matters that should be left up to Congress, left up to the executive. I mean, in fact, at one point the Supreme Court struck down a Bush administration policy regarding the detainees in Guantanamo and said that Congress needed to be involved, so the Bush administration went back. They got Congress involved. Congress made the changes, and the court struck down that plan as well.
Yeah, right. I mean, there's clearly a refusal to take into account the structure of the Constitution and of separation of powers and the competition that's implied. And even if you think you have a president doing these things that you disagree with, help was on the way with the 2006 election, and then the election of Barack Obama. So there's, right. I mean, there's throughout our government on so many issues, the court is really upending the sort of competitive structure of the Constitution.
Sure. And by the way, is it the role of the judiciary to act when they perceive that Congress is not doing its job?
No, exactly.
I'm not throwing.
Well, no, but it's a worthwhile question, because even if they presume they have the power to act, on what basis, what facts, what understanding, what competency they're going to act upon or with.
Right.
Yeah. And thinking about the Bush administration and where it ends up, you note in the book, others have noted that except with regard to the enhanced interrogation techniques, and those largely, in my understanding, is in 2003 in any event. But with regard to the enhanced interrogation techniques, Barack Obama, though, has continued most of what George W. Bush was doing in fighting the war on terror. I mean, that's a broad statement, but we can qualify it a lot. But it doesn't seem there's been any significant departure on his part.
Yeah, certainly during Obama's first term, and that's when my book was written, it did seem to be, that his administration's slogan should be continuity we can believe in instead of change we can believe in. I think a number of the practices were continued, although I certainly see in the second term a kind of different Obama presidency, and one that's somewhat at odds with the way Bush would have approached things.
Go ahead. No, you go
ahead.
Well,
I guess I would still make the case that when Bush and Cheney limp out of town on January 20th, 2009, that the forces that were pushing back had the upper hand over the sort of Bush-Cheney conception of presidential power.
Yeah. Yeah, no, it certainly, I mean, throughout the administration, throughout the country, it felt that way. Although it is interesting, the irony here, and we could discuss this, is thinking about, so Barack Obama comes into office, and what's one of the first actions he does, but through the power he has as the president, he completely wipes away basic precedent in bankruptcy law, stiffs the creditors of
Sure.
GM and Chrysler, and awards his political friends with better contracts, like with the UAW, in the midst of the bailout of the car companies. Now, of course, that process of bailing out the car companies started under Bush, but Barack Obama takes it to a level of discretion, of executive discretion that was, and to this day, I think, should trouble all of us. Think about the foreign policy, and of course, I mean,
and by the way, he also signs an executive order saying that Guantanamo will be closed down within a year. We know how well that worked out.
And it's overall, it's almost as if you could argue, I think, credibly, what Barack Obama is doing is incredibly dangerous because he's exercising discretion in a domestic policy context.
Great point.
Where there's no support for that.
Extremely valid point.
There's no support there. On foreign policy, maybe we can, I mean, I don't want to re-fight or rediscuss the Iraq War. George W. Bush announces in the September 20th speech, we're coming for the terrorists and we're coming for the states that support them, harbor them, defend them. And then we did something, I think, other than that. How do you understand his foreign policy regarding Iraq and the decision to invade? Do you think it was an after the fact decision to stick around and rebuild the country and rebuild a democracy, or did he always have that conception going in, or can't we even really tell? It was just as he went.
I don't know, Richard. I can't tell, honestly. And of course, the way that occupation, if you want to use that term, was handled was problematic, to say the least. I will say this: the initial decision to go into Iraq, I know people belittle it by saying there really is no extensive al-Qaeda links, which is basically true, although not totally true. Yeah. But Saddam was a notorious terrorist harborer. But I think the bigger issue for the Bush administration was they were trying to send a signal that we were going to drain the swamp, to use a somewhat crude phrase. In other words, the days of these kind of lawless states in the Middle East were numbered. The hope was that by toppling Saddam, it would send a shockwave throughout the Middle East, that it would impact Syria, that it would impact Iran, that it would impact Gaddafi in Libya, which, by the way, it did. Gaddafi immediately takes steps to eliminate his atomic weapons program. There was a brief period in Lebanon where it appeared that the Lebanese were going to finally shake themselves of the Assad family influence. There was a kind of democracy or early Arab Spring in Lebanon that unfortunately petered out over time. And there was even a brief period where Iran was sort of cooperative or sending signals of cooperation to the West. So initially, due to the successful 21-day invasion of Iraq, the shock and awe, if you want to borrow a term, policy kind of worked. Unfortunately, it was all frittered away in a botched occupation, which, by the way, I think there's a big untold story about that in terms of the constant battling between the State Department and the Pentagon over the correct policies to pursue in Iraq, but that's a separate story.
I've always thought that Donald Rumsfeld had an understanding that we would go in, decapitate the regime, and leave.
Correct.
Regardless of the consequences. That kind of gets into, there's another view out there that you found, there's some essays that support this, Mark Halperin's essays in the Claremont Review, that, somehow that what was needed was to clearly go after terrorists, and if that led to fall of certain regimes, so be it, but you didn't have a responsibility to support them or build them up. But that seems to be never really pursued by the Bush administration.
No, that's right. And by the second term, President Bush is sounding like Woodrow Wilson, and he's talking about, building democratic institutions throughout the Arab world. And of course, that just did not succeed as most folks would have predicted. So.
Yeah. Well, Stephen, I want to thank you for your time in discussing your book with us today. The hardback came out in late 2012, and then the paperback came out last month. So I look forward to getting further sales circulation of the book. The book is Rush to Judgment, George W. Bush, the War on Terror, and His Critics. Thank you, Stephen Knott.
Thank you, Richard. I appreciate it very much.
This is your host, Richard Reinsch, and you have been listening to a podcast that can be found at libertylawtalk.org, where you can subscribe, comment, find other episodes, and links relevant to today's conversation. Our email address is mail@libertylawtalk.org.